Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3010, United States of America versus Deenvaughn Rowe, also known as Deenvaughn, appellant. Mr. Coburn for the appellant, Mr. Booth for the appellate.
Good morning.
Good morning, Your Honor. May it please the court, Barry Coburn for the appellant, Deenvaughn Rowe. What I would propose to do is to direct the court's attention or ask the court to focus, I should say, on one particular aspect of our argument, of what we noted in our opening brief, which has to do with the several witnesses that Mr. Rowe identified for his trial counsel. And with respect to those witnesses, what happened or didn't happen in terms of Mr. Rowe's representations is essentially uncontested. There appears to be no dispute that his trial counsel talked to, I think, 3 of them, but then there were a series of them that he didn't talk to. And never made contact with. There's no evidence that he sought to. And the problem with that from our standpoint is, what happened basically in this case was what we as criminal defense counsel will refer to colloquially as a sort of a slow plea. And part of the reason for that was because, at least as far as I can tell from reviewing the record, the jury really never had any reason to doubt the proposition that with respect to the contact with Mr. Rowe's computer, which was really the centerpiece of the prosecution of him, that he did that. There was sort of a vague suggestion out there that, the door was open and other people could have used it. That's really very unpersuasive evidence from my standpoint, vis-a-vis what could have been developed, which was evidence that other employees, co-employees, actually utilized his computer on a regular basis. And
this as a factual matter, counsel, wasn't there evidence from the government's own evidence that was used by Rowe's counsel below to show that 2 devices were logged in at the same time, which would suggest that someone else had the ability or access to log in using Mr. Rowe's credentials?
It's probably consistent with that proposition, Your Honor. The fact that 2 computers are logged in at the same time for the same user can connote the notion that the user is simply using one computer and then another computer sequentially. But the more fundamental point from my standpoint is that evidence, even if it suggests exactly what Your Honor just indicated, if it suggests that others might have used his computer on, say, one occasion or something like that, that's not, I would suggest to the court, functionally equivalent to the proposition that there are a series of other individuals who used his computer, used his login on a regularized basis. And there is sworn testimony in the 2255 hearing to that effect from Mr. Rowe. There's no evidence to the contrary. And so there's every reason, I would suggest, to believe the proposition that had his trial counsel located, interviewed, and presented the testimony from these individuals, the jury then, would have had something, I would suggest, far more substantive, Let
me ask this question. Suppose the case is a shooting that happens on, January 1st at noon, and the defendant tells his lawyer, well, on January the 1st at noon, I was at a picnic at some other place, and there were 10 people who were with me at that picnic and who would be able to testify that I was there. And the defense lawyer speaks to 3 of them and they say, I don't know what you're talking about. There was no picnic on that day. Does not speak to the other 7. Do we just presume ineffectiveness because we presume that the other 7, or at least one of the other 7, would have corroborated that the defendant was at the picnic with them? Or would we require some sort of showing that at least one of those 7 witnesses, that purported witnesses that wasn't spoken to, would actually say that?
My suggestion to Your Honor is that the metaphor is problematic for the following reasons. If you have 10 people at a picnic and you interview 3 of them and all 3 of them say that there was no picnic on that date and time, then, I mean, that's persuasive evidence right there that, you know, to that proposition that there was no picnic. And so I'm not sure that I can make a credible argument that it's necessary to talk to all 10 of them to see whether anybody's going to contradict what the 3 said, that there was no picnic. But here, you know, you've got a situation in which these people are engaged in activity independent of one another. So in other words, if trial counsel had interviewed one witness and that witness said, no, I never used Mr. Rowe's login, that is not persuasive of the proposition that witness number 2 would say the same thing. So that, I think, is a fundamental difference. And so, moreover,
I take your point, but I guess, and that is, I think that's a fair distinction, but I guess my bigger issue is you have to establish prejudice. So even if I were to agree with you that it was deficient performance to not have interviewed every single one of these witnesses that Mr. Rowe identified, how do I know that there was prejudice?
I focused on that very question as well, Your Honor, and I focused on several cases that are cited in our opening brief on what constitutes a showing of prejudice in the 2255 context. And here I'm referring to the Fatum Bahirtu v.U.S. case. Blakeney and Strickland actually addresses this too. So it's, I mean, one might sort of intuitively think that it would be necessary to demonstrate, you know, so let's say to a preponderance that the result would have been different, but that's not actually the standard. What you have to show is whether there is, and here I think I'm quoting from Strickland, whether there's a reasonable probability that absent the errors, the fact finder would have had a reasonable doubt respecting guilt. And here.
So what do you think is involved in showing that, right? Because what would have been very helpful is for us to have some idea what these other witnesses would have said. But there's no attempt to go interview them now. There's not really a record from which we could do anything but speculate.
I've thought about that very issue, Your Honor. I think as I stand here, I have to concede that in the context of the evidentiary hearing below, before Judge Chutkan, it would have been preferable to have an investigator go out and interview these witnesses and present testimony from the witnesses themselves and or the investigator, if that's not hearsay. But I mean, to establish a record, you know, to a greater degree of specificity, I've got to concede that would have been preferable. But there actually is a record here, even if not a perfect record. And I think Judge Chutkan may have, we disagree with the conclusion in Judge Chutkan's memorandum opinion that there was no showing about what these witnesses would have said, because what you do have is the appellant's own sworn testimony in the hearing, in the 2255 evidentiary hearing below.
Okay, I have one more question then about deficiency, which was sort of the next step, I think, in my mind from what Judge Wilkins was asking, because Brennan actually says at the hearing that I understood the setup of this office. There was a computer in the front and a computer in his office. And even if Steele and Saunders had said, yeah, every day people are going into his private office and using his computer, I wouldn't have called them, because that would raise all sorts of other questions that could have been harmful to our defense. And this is his explanation. Then you have, it sounds like we're trying to prove who it was rather than creating reasonable doubt. It's on pages 346 to 49 of the JA. Anyway, why isn't that a reasonable judgment? Even if I could have had testimony, it would have opened them up to damage and cross-examination. What's wrong with that explanation?
And of course, that's exactly the rub, if you will. That's the issue you run into in virtually every 2255 case where, the trial counsel whose performances.
This is not a 2255. We're still on direct appeal here. We remanded from the direct appeal, just so you know. I'm sorry to interrupt. Go ahead.
I may have misunderstood the question then, because I thought what was being referred to here was Brennan's testimony about, the notion that I wasn't going to call them because they would have been subject to adverse cross-examination, which is, of course, always a possibility. I mean, you can't eradicate that as a trial lawyer. But here, I mean, in terms of like the reasonableness of the tactical judgment at issue, how would eliciting testimony from a witness, to that effect, as Your Honor just described it, that they were like routinely utilizing his computer? I mean, and of course, I mean, I could speculate that there might have been other adverse things that could have been elicited from these people on cross-examination. But I mean, that would have been, it would seem to me, an absolutely critical bit of exculpatory testimony. I mean, that would have actually given trial counsel something to argue, something substantive to argue. That, ladies and gentlemen, you can't tell, you don't know that this was him who did this. Now, of course, I concede, there's other evidence against Mr. Rowe at trial. There was some surveillance testimony and so on. But that would have been at least, a substantial kernel of reasonable doubt, which I think meets the prejudice standard.
Can you identify any case where a court has said that we will rely on the defendant's testimony about what purported witnesses would have said to establish prejudice in the absence of any sort of even hearsay from an investigator from those witnesses?
I don't think I have that case. I have a recollection of having read authority to that effect, but I don't have it at my fingertips. And like I said, I acknowledge it would have been better to have some additional investigation done following remand prior to the 2255 evidentiary hearing. That would have been better and would have given the court more to work with. But I guess my response to Your Honor would be, I don't think there's any per se reason why, because I mean, the defendant isn't just speculating. I mean, he's testifying based on his own observations and interactions with these individuals. And so that would seem to be competent testimony. And of course, I mean, I recognize he has a substantial interest, but nonetheless, I don't think that disables him from providing that evidence.
You've mentioned a couple times how much preferable it would have been to have had some actual evidence gathered. You were not counsel for the remand hearing, which I remind you again was not a 2255. It's just our procedure. It's still all direct appeal, no 2255.
Oh, I understand. I'm sorry. I misunderstood Your Honor's point.
Yes.
I have it.
Right. You weren't counsel there. But in fact, when you brought this appeal, you filed a motion for summary reversal on the basis of the incompetence of the attorney who handled that remand proceeding for failure to do the very thing that she said she was going to do, and that is interview witnesses and make the very record that everyone knows needs to be made on these types of showings. And the panel that heard that summary reversal decision said, we're not ready to summary reverse. We're referring this to the merits panel. And you must brief it to the merits panel. And if you were right that she was incompetent for failure to do the very thing that needs to be done in this type of proceedings, that could have been an important claim to be presented here. But it's nowhere in your briefs. And I'm really quite baffled, given that your argument recognizes how harmful it is not to have the record made when the opportunity was given.
I take Your Honor's point, and I'm thinking back a ways here in terms of what our rationale was for approaching it that way. And I'm not sure this is going to be a satisfactory explanation to Your Honor. But what we're authorized to pursue as appointed counsel here is the direct appeal of Judge Chutkan's determination below that trial counsel was ineffective, not a direct appeal.
You filed a motion for summary reversal and remand for that. So that clearly was within your wheelhouse. And if that's part of what's needed to be done, if you need to show that person was ineffective, so you have a record to show that the other person was ineffective, I see no colorable argument that that's not within your wheelhouse. And you thought it was because you filed the motion and 2 members of this panel thought it was worth sending to this very panel for a decision on the merits. So that seems to me I guess I'm not understanding that explanation. If you thought you could file the motion, then you could certainly, the panel told you could brief the issue. I don't know what more authorization you need.
Understood. And that easily could have been a mistake on my part. But that, if I remember correctly, was our thinking, that we were not empowered to do it, at least with respect to pursuing this appeal. That's not to say that there might not be, and of course, I don't, as I stand here right now, I don't know procedurally, precisely what options Mr. Rowe would have in that regard. But I believe we concluded, and we may have been wrong, I believe we concluded that we couldn't pursue it in this context because it's not within the scope of what we were authorized to appeal.
Was it competent for attorney at the remand proceeding not to investigate any witnesses, not to make a record?
Well, as Your Honor correctly notes, there was a position taken earlier to the effect that it may not have been competent. I mean, that's just an excellent question. I'm not there. I think you might be within, some sort of a reservoir of tactical judgment. And that would, depend on the specific conversations about what Mr. Rowe knew about what these witnesses would have said. So I suppose you could envision a scenario in which a tactical judgment could be made that I'm not going to hire an investigator. I'm better off with Mr. Rowe's testimony.
Because the heart of your argument for why trial counsel was ineffective was you got to talk to the people and you got to ask the questions. You don't know what you don't know. No one's yet saying you can't know whether someone was effective strategically or ineffective for failing to put a witness on without having first figured out what that witness is going to say. You don't know what you don't know. And so given that that's your argument here as to trial counsel, I'm a little confused by your argument that somehow the attorney on remand could have just decided, I'm not going to bother to interview or ask anybody. I'm not going to do an investigator. Having said I was going to interview these witnesses, I did not interview these witnesses. So how can you make an uninformed strategic judgment, I guess is my question.
I don't think I have a good answer to that question, Your Honor, and I do take the court's point with respect to it. I don't think the 2 scenarios are necessarily precisely identical. From the perspective of Mr. Rowe's trial counsel, he's interacting with a client prior to a jury trial. The client says, these, I guess it's 6 or 7 individuals have information which is substantively exculpatory. And this responds to Judge Garcia's question as well. I don't think I see a legitimate tactical argument as to why you would not hire an investigator to interview those people. With respect to the second lawyer who handled the hearing on remand, that might be different.
I don't know why you're bothering to defend it. I don't understand why. The whole point of that hearing was to gather evidence. That was the whole purpose of it, was to gather an evidence and make a record. And that didn't happen.
It certainly didn't happen in that regard. I agree with Your Honor's observation to that.
You thought, or appellate counsel thought at some point here that it was so obvious that there should have been a summary reversal. and remand for yet another ineffective assistance hearing.
Understood. And, as I said, Your Honor, that may have been a misjudgment on my part in terms of not including that in the merits brief, in our opening brief. My best recollection in terms of our thinking at the time was that we concluded that we might not be allowed to do it in this context, and it might require, a separate proceeding in which an allegation is made below about ineffectiveness of the remand counsel, but I could have been wrong.
Other questions?
I just have one more sort of type of question, which is about what do you understand this argument to be that the lawyer didn't review discovery with him? What evidence is he saying the lawyer didn't review with him? Because on one view, it sounds like a lot of the primary evidence in the case, he's claiming his lawyer didn't review with him. And that would look a lot like a big problem, but it's all very vague.
Well, it is vague, and there was extensive testimony below from his trial counsel about what discovery materials he showed Mr. Rowe and reviewed with him when Mr. Rowe was incarcerated, and what materials he didn't. And it sounded from that
Do you
testimony.
think the trial court credited Brennan's version of that?
Absolutely. I mean, I didn't see anything in the trial court's memorandum of opinion suggesting she didn't credit it. And I'm not sure in my own mind, as I sit here, I may just be having a failure of recollection, but I'm not sure how directly inconsistent Brennan's testimony about what he reviewed with Mr. Rowe was vis-a-vis what Mr. Rowe said was reviewed. It may have been directly inconsistent. I sort of emerged with the impression that it might not have been. And if Brennan's testimony is credited, it sounded like, he made a cut in his own mind in terms of what was substantively significant at trial and what likely wouldn't be.
Okay.
I'm curious as to the basis for inferring a finding of credibility, because I just don't recall the district court order having addressed this discovery issue.
At all?
Didn't address the district court's memorandum of opinion, did not make a credibility finding. Are we to just infer it?
I'm sure Your Honor is right about that. I mean, I emerged with the conclusion. I mean, I thought there were observations in Judge Chutkan's opinion about the review of discovery materials. I may have that wrong. I may not be remembering it correctly, but I thought she
But
did.
see, it's right. So on the face of the opinion, there is no finding about what discovery was reviewed with Mr. Rowe. There was also a very direct and important conflict between what Mr. Rowe said and what Mr. Brennan testified. But maybe this is just another area where remand counsel was incompetent, because he says, I did not know they seized 2 phones from my car, and that was used at trial. And I would think that a good appellate argument would be they didn't review some of the central evidence in the prosecution against my client. And if he had, he would have made some other choices, but
Well, I
not
think there
focused
is.
on that today. So maybe further questioning isn't productive.
That may very well be. I mean, I wish I had a better, a clearer, more specific recollection of exactly what Judge Chutkan said in her memorandum of opinion about this. I could have sworn that there was a recitation in there about what discovery materials she found had been reviewed, but I may have that wrong.
Any other questions? All right. Thank you very much. We'll hear from the government.
Thank you.
May it please the court. Mr. Brennan, Rowe's defense counsel, gave effective representation to Rowe at his trial. And even if he didn't, Rowe wasn't prejudiced at all.
How can it be effective I'm not talking about once you gather all information, making a strategic judgment about what your defense should be, what witnesses to put on or not put on. How can it be effective to not even talk to them? With respect to what was going on with these computers, she talked to one person who did not work in the office. off point, talked to one who said, yeah, there was some of this, but people didn't go back in his office very much. Now, if the other two had said, we were in his office all the time, that would have been a monumentally different calculus for a defense counsel. Not saying how we would review an ultimate decision, but it would be an informed decision. And this attorney, the trial attorney, didn't bother to get informed about something that was pretty critical to a defense case. Critical enough that he tried to argue it with one hand tied behind his back. How can that be competence?
I think in terms of evaluating competence, you have to look at the overall performance of the defense attorney in what he did to investigate the login procedures. And in this particular case, he had heard from Rowe himself about what the login procedures were at the post office. So he already had that in his mind. Now, he also then interviewed a second person who told him that other post office officers told him that they did not otherwise go into Rowe's office. And he also made a strategic judgment.
My question was how you can make an uninformed strategic judgment. You just set it up. That Mr. Rowe said one thing. The one in-office witness that he interviewed supported part of what he said about people logging in multiple times and using each other's computers, supported him halfway, but then said, well, we didn't go back in his office that much. All right. Why? That just simply raises a question, a conflict. You don't stop there. Then you talk to the others. No one would make an important life decision without getting further information in that situation.
Yes, but he had already made a determination of that.
And he made an uninformed determination.
It was not an uninformed. He had already interviewed a couple of witnesses with
Again,
respect to this particular.
We've gone for this. The first witness didn't even work in the office. So put that one aside. So now we're down to one witness who corroborated some of his story, but for the other part was much more qualified. How can you decide to stop when someone says, yep, yeah, I agree with part of what he's saying, but the other part, I don't know that I agree with. Why? And you've got two more people who worked in that office you could talk to get a full story. How can you make a strategic judgment based on that scanty information?
Well, again, you have to realize that he had talked to Rowe, and if there was any one individual.
He gave them all the individual names.
He had given names, but he had also Rowe himself.
Yeah, but he wasn't going to put Rowe on the stand.
Well, I know he wasn't going to put Rowe on the stand, but he had already made a determination of exactly what the particular problems were in that case, what he was going to have to do to try to show that other people had access. And he also.
We're kind of going in circles here because you say he'd already made up his mind on his strategy without bothering to talk to the witnesses.
Well,
Is that what you're saying?
what I'm saying is that a defense lawyer does not have to speak to every potential.
We're not saying everyone. Judge Wilkins' hypothetical was a good
Right.
one where that wouldn't happen. But here, where you actually have someone saying, yeah, he's actually partly right. There's something to this, but there's this issue of his own office. So then we need to pin this down.
Well, that is true, Judge Millett, but I would also like to point out, in addition, you're saying, well, they did not interview those two witnesses, but there were other things that he did that showed that he did a reasonable investigation in this case.
Wait, I'm sorry. Other than that central defense offered by the defendant, he did some nice things over here. Is that competence?
Of course it is. What happens is that,
Of course it is.
what happens is, Judge Millett, is that the Supreme Court has said in Strickland that there's a great deal of deference that you give to choices that defense attorneys make.
Informed choices.
Informed choices.
Is there a case that has said uninformed choices?
Well, of course not. No, there's no case that says uninformed choice.
And I'm asking you why this is not an uninformed choice situation.
Well, because he had already done an investigation, he'd already made a determination
We're
in
going
his
in
own
circles
mind.
here. He'd already made it. Okay.
I'm saying these two witnesses.
He had already talked to one. Again, two doesn't count for me because one didn't work in the office. So one witness.
One witness and also Rowe's own
And he
testimony.
made up his mind.
And Rowe's own information that he gave to him. But assuming,
There's a conflict between those two. So a conflict, you just say, I disbelieve my client. This other person actually wasn't saying he's wrong, just had a perspective that people didn't go off in his office that much. But imagine the next person said, agree with the first witness that we were using each other's computers. Most of us did not go back in his separate office. I mean, occasionally would, but pretty rare. But this other person, he was back in Mr. Rowe's office all the time. Would that perhaps inform a different strategic judgment?
If those were the facts, if you had a witness who had testified at this evidentiary hearing that, yes, we were in there all the time, and we had other Postal Service employees who were using his login
Wait,
procedures
you're
all
at
the
this
time.
evidentiary hearing. I'm saying you're like me. It's like, wow, that would be a whole different thing. Still not saying how you would actually handle the defense, but it would be an informed judgment.
It would have
And you're
been,
like, wow, yeah, that would make a difference had we talked to that witness.
if you talked to that witness and if those witnesses had said exactly what
Well,
the
not if he
defendants.
talked. We know he didn't talk.
We know he didn't talk to him, but we also know that what the attorney did in this case was a reasonable investigation because he talked to a couple
We
witnesses.
don't know that.
Well, if you don't know that, well, let me then pivot to the prejudice issue here. And that's why I wanted to begin my
Well,
argument.
I just wanted to pin down with you on this because you started by saying it was competent and reasonable, and yet we're all agreed that uninformed strategic decision.
I would agree the legal,
I'm going to finish my sentence, is not competent representation. And there was a complicated story going on here, at least it was unclear story at the time he made a decision. It was quite unclear and foggy what was happening in that office, and he just plowed ahead forward without that.
I actually don't think it is all that unclear what was happening in the office. Again, if I could pivot to show what the government's evidence was in this case. The government's evidence it showed in part that there were text messages between Rowe and his two co-defendants. And the text messages had at least one of them. And again, you can look back to the Court of Appeal, your court's decision in the direct appeal in this case. And so one of them, the text messages had tracking information. And if that's the case, then that shows that who's doing the tracking. It was Rowe doing the tracking. It wasn't some other person in the postal
Were those
office.
text messages from his own phone or a burner phone?
I'm not entirely sure it was, but that was part of the government's evidence at trial.
Right,
Remember
but
the
that
government.
would matter as well.
I might be, but again, the point, and I wanted to pivot primarily when I started my argument, is that this court should start off with a no prejudice contention, because Strickland says, one, you can do that. You don't have to go to the ineffectiveness prong if you don't want to. And second, the reason I wanted this court to go right to that was because in Massaro, the court said that the court that did the trial and that handled the evidentiary hearing has a most advantageous perspective on the case. Now, Judge Chuckett in this case made a specific determination that the evidence was extensive and it was strong.
We don't have any ruling from Judge Tutkin, as you have conceded, on this argument about failure to share discovery with the defense. Doesn't talk about it. So what do we do with, to the extent we want to give, of course, the front row view of the trial judge gets enormous respect. So when we have nothing but silence on, as Judge Garcia mentioned, a really important issue, we've got nothing to defer to. What are we supposed to do? And we've got a real conflict between Mr. Rowe and Mr. Brennan. What are we supposed to do?
In cases in which there's a conflict in testimony in an evidentiary context, like at a search and seizure hearing or whatever, where you have a conflict and you have a district court that does not make a specific finding of credibility, it is normally the
Or a
practice.
factual finding.
Or a factual finding. It is the normal, not exclusive practice of this court to defer to what would be the implicit determination
What's
to
the
the winning
implicit
side.
determination about an issue that's not mentioned at all?
Well, when you say it is not mentioned at all, the district court said specifically in this particular case that Rowe did not specifically identify what discovery Brennan did not review to him. And then she goes on to say, and then Rowe has not demonstrated how his review of all the evidence would have led to a different outcome in the trial. Now, she says that Brennan admitted to not having reviewed electronic evidence that did not involve him, including discovery pertaining to his co-defendants. And so the court then goes on to say, then Rowe has an established prejudice in this case. So the district court did make a finding of no prejudice with respect to that.
But what about this dispute about these phones that, I mean, I don't know what he means by electronic evidence, but if that means phones found in his car, or they were burner phones, that would be important to review with your client because he already had arguments that a piece of paper found in his car was more likely associated with his
Well, that's true, Judge Millett,
one
but
of his
again,
co-defendants, like the mother of his child, than him, and he could have explained the same thing about the burner phones, equipped the defense attorney to be much more effective on cross-examination at a bare minimum.
on direct appeal from this case, in evaluating the extensive evidence against Rowe, this court referred in part to the incriminating evidence from the text messages. And they reviewed that as incriminating. And we view that again as part of the reason why Rowe can't show any prejudice. in
Why
this
would we have
particular-
bothered remanding if our analysis of the evidence had already foreclosed any finding of prejudice?
I'm not saying that. I'm saying that in reviewing the evidence that the district court did, the district court in part relied on the evidence that was described by this court on the direct appeal in this case. And what we're saying is the same way she described it, and she was the trial judge, as extensive and strong. And when you take all that evidence and view it together, and not as isolated bits and pieces, the evidence against Rowe was absolutely, in our view, overwhelming. And so that, yes, there may have been something that might have been done a little bit different. Brennan may have interviewed a witness here. He may have done a little bit review of discovery with respect to the surveillance tapes that involved somebody else. It would not have made a difference in this case.
But the way you've just described it is that one of the key pieces of evidence was the text with Brantley. And that's what he says that his lawyer didn't review with him. And maybe he would have been able to come up with a defense to that key piece of evidence against him in the case. But his claim is that his lawyer never reviewed that evidence with him.
Well, Brennan said he did review all of the important evidence.
But we've all agreed that there's no explicit finding from Judge Chutkin about what evidence the lawyer reviewed with the defendant.
Right.
So if it were the case, right, that texts from these phones found in his car were the key thing to incriminating him, and his lawyer never showed him that before the trial, and it's his words, both he and the lawyer were both shocked, that would be a pretty good claim of arguably even just deprivation of the assistance of counsel. You're withholding the key evidence, so we can't prepare for trial.
Rose said that he was surprised, but Brennan said he was not surprised. So Brennan was not. If you have that conflict, our position is you get a conflict between the defendant and the government's witness at a suppression hearing, and the district court denies the hearing, then our theory is, and our position is, that you have to accept the testimony of the witness who, in this particular case, I reviewed all of the relevant evidence with him. I did not review the discovery relating to the tapes of the co-conspirators. So we would submit that there's the implicit finding that the district court found. And even if the district court didn't make
a question about that. So to be clear, where my concern would lead at most would be a remand on the theory that we don't know what Judge Chutkin found about the extent of the review of discovery. But you've relied on this Johnson case, and there's a question about that case for this proposition that we can sort of make our own fact finding. Am I right? That case involved, there was just no written findings at all. And in ruling on a suppression motion, it seems at least a bit different, where we have a pretty extensive opinion from the district court, and the government is still asking us to sort of impute an unstated factual finding to the district court. Do you have a case that looks more like that?
I believe I cited the Evans case in my brief for the proposition that in normal context where there are no specific findings of fact made by the district court below, then on appeal, you normally assume that the facts are in the light most favorable to the prevailing party. So if you have a dispute here, then it would be if Brennan says, I did review all of the important discovery. I just did not review the testimony relating to the co-conspirators on the surveillance tapes. then we would submit that the district court, having ruled against Rowe in this context, should accept Brennan's testimony on that particular point. And in any event, I mean, you mentioned about sending this back for a remand. Inasmuch, again, the district court said that Rowe's review of that evidence would not have changed the outcome of this trial. So even assuming there may have been an error in this particular case, and we do not concede that there was one, there is no prejudice in this particular case. I know I've said this a couple times, but Judge Chutkin said the evidence in this case was strong and extensive, and she had that advantageous position over the case that the Supreme Court mentioned in Massaro.
So can I ask you a question, a clarifying question? Are you familiar with the actual evidence that came in at trial and what evidence came from all of the different phones?
No, I just have a general idea of the evidence that came in. I did cite to the government's opening brief in this court, and that brief does contain a fairly extensive recitation of all of the evidence that's pertained to Rowe. And I'd ask you again, Judge Garcia, that this is not a question of looking at all the evidence, including the surveillance tapes and looking at the unexplained wealth and all of that in isolation, but to look at them together. And when you look at all of that evidence together, there's not a real chance that he could show any likelihood that he was prejudiced by any errors committed by the defense attorney.
If you have a case, from this court or another court, it would be helpful where this, we round up everything in favor of the government, because the district court ruled for the government, even when there's no discussion of a disputed fact issue at an ineffective assistance of counsel hearing, not a suppression hearing.
I didn't find a specific one, but I would imagine that the rule should be the same in both contexts.
I would imagine not, because the point of a whole ineffective assistance of counsel hearing is not to review the trial that happened, but to figure out what didn't happen by counsel and whether, if it were incompetent, these are all big questions, if competent counsel had the reins and investigated evidence and talked to witnesses and been able to formulate a defense strategy that way, would it have been a different record? Would the trial, that's the whole question, was there the chance of the trial would have had to come out differently, right? That's the prejudice standard. And so I'm not sure how we can, in an ineffective assistant counsel, say, well, given the ineffective assistance of counsel, everything was overwhelming, when the district court could have found that, in fact, it would have been a different story. I'm not saying they would in this case or would not. I'm saying we have such a vacuum of information from what Mr. Brennan didn't do and then what remand counsel completely dropped the ball on, that I don't know how we can just go, well, let's just assume everything would have been the same and the government's overwhelming evidence would have been just as overwhelming. It was all circumstantial evidence as to him. It was burner phones. It was his computer in a place where people used others' computers. I'm not saying you can win on circumstantial evidence. There's no doubt that you can. And I'm not saying it wouldn't be enough. But you don't have videos of him. And I think, if I recall, and you can correct me, a lot of the text messages were from burner phones, not his personal cell phone. So it's one of those where it's hard to put into my head, at least, what this would have looked like if we'd at least had a full record on the competence of counsel in the first place.
Well, I think the record is adequate. And again, one salient piece of evidence that goes against him is that unexplained wealth. When you put
that was again another investigation problem, though. So
yes, but let's assume with respect to Cranko that he didn't interview here, she might or may not have said that he had won $20,000 in the football pool. That wouldn't have even come close to refuting the government's evidence that Rowe had.
He also needed to investigate more about the business, go out to the track and see what he was winning. I mean, this guy's winning $20,000 in football pools. Maybe he's a big stakes gambler at the racetrack too. I'm not saying I'm saying we don't know what we don't know. And after a remand, we still don't know what we don't know in this case. It could be very well exactly what your view of the evidence is, but we don't know what we don't know about what the defense could have discovered and either put on as witnesses or been able to much more ferociously attack the government's case and change the complexion of the record.
But it was not, it was a strategic decision on his part that even if he had put on the $20,000 evidence, then the government would have come back and said, yeah, but we have a lot more unexplained wealth. And Brennan made a strategic determination. As he said earlier, nothing messes up a defense as putting one on. And if he put on the
Very
20,000.
odd statement to make, but go ahead.
No, he was talking about you have to close all the loops when you're presenting an affirmative defense. And his point was simply that $20,000 wouldn't have done it, okay? He had way too much unexplained wealth. $20,000 would have
And
gone
that would
against
be
me.
a great strategic gut judgment if we knew that was the whole story about his alternative sources of income. I mean,
I
you
would
yourself said an uninformed strategic judgment is not competent.
I don't buy that premise that it was an uninformed. I would
No,
say he did.
I'm not saying it is yet either, right? This is what we don't
Right.
know from the remand proceeding. But it was uninformed in that he didn't collect the information. I am saying that. But it could have been he talked to everybody and it all would have come up way short. And then it would be a very informed and probably wise strategic judgment not to try to tip the whole thing based on one football pool. I get that.
Okay, but again, our position is that he did a reasonable investigation because he did ask Rowe about his so-called winnings at the track. He talked to Harris about the promotion business. He talked to the family about the football pool. In our view, that was a reasonable investigation, even if he didn't interview Cranko, and even if Cranko would have testified that there would have been $20,000 from a football pool. That would not have eliminated the vast degree of unexplained wealth that the government had.
But can I, if you'll indulge me, this is less of a question than a comment on how the government briefs and argues these cases, and it goes to prejudice. So it's not particularly helpful when we get a vague statement, a reference to a brief in the prior appeal and to the district court's sort of general statement that the evidence was overwhelming. It's more helpful if we're actually pointed to what the relevant and most important evidence was. And to make that much more concrete in this case, we've been talking about investigation into who was on the computer and 2 phones that were seized from his car. We did go back to the trial transcript, and it looks like for almost 2 full days, the prosecution walked through real-time phone calls and texts from a phone not taken from his car, but that was seized from his person when he was arrested and that he stipulated was his phone. And if that's the case, then you would have had a very straightforward no prejudice argument that would have been much more helpful to the court, because that was on the observed marked packages being delivered and him communicating in real time. And it seems quite clear to me, if I understand that correctly, that there's no possibility that there was any prejudice here. But it is much more helpful if we're concrete in the briefing. It gives the defense a chance to respond and make sure we don't make mistakes.
I acknowledge that, Judge Garcia. Thank you. No further questions?
All right, thank you very much. Okay, Mr. Coburn, we'll give you 2 minutes.
Very kind of you, Your Honor. Actually, as Your Honor noted, I reserved 2 minutes, but as I was listening to the both parts of this argument, I'm not sure I have anything affirmatively to add, but of course, happy to answer any questions the panel might have.
No. Questions? All right, thank you very much, Mr. Coburn. You were appointed by the court to represent the appellant, Mr. Rowe, in this case, and we thank you for your assistance.
Thank you, Your Honor.
Case is submitted.
Case number 20-1107 Evan. Clean Fuels Alliance America petitioner versus Environmental Protection Agency. Mr. Len for the petitioner, Ms. Kimball for the respondent, Ms. Dawson for the interveners.
Good
Morning.
morning. David Lane for petitions. I'd like to reserve 3
Is it
minutes.
Len? I'm sorry, I didn't hear you right. Len, Lane?
It's Lane, but I'll respond to either one.
Oh, no, I want to honor you by getting it right. So Lane, okay, thank you.
And I'd like to reserve 3 minutes, please. May it please the court. In the 2020 RFS rulemaking, EPA considered the issue of what to do about retroactive exemptions when establishing annual RFS standards. EPA determined that henceforth, when setting standards for a particular year, it would adjust the standards to account for the exemptions granted retroactively for that year, but not adjust the standards to account for exemptions granted retroactively for prior years. EPA codified this policy in the regulation that defines the formula for computing standards. The logic of this court's precedents and EPA's own statements imply that this policy is unlawful because it compels EPA to violate its core mandate of setting standards that are reasonably designed to ensure that the national volume requirements are eventually met, and because it compels EPA to engage in arbitrary decision-making by setting standards that it knows ex ante will be ineffectual. This court has said in the Reset case, Sinclair, and others, that if EPA does not adjust renewable fuel obligations to account for exemptions, it creates a renewable fuel shortfall and impedes attainment of overall applicable volumes. Our claim is that EPA is legally required to make those adjustments, including for past retroactive exemptions. I'd like to just be clear about how our claim works. There are really 2 different scenarios in which adjustment to the standards is needed for past retroactive exemptions. And they call
Before we get into the merits, what is the final agency action that you are asking us to review?
the 2022 rule in which,
2020.
the 2020, I misspoke, the 2020 rule.
I think that might have been a Freudian slip.
I hope it was not, but definitely the 2020 rule. That is in that rule, EPA reaffirmed and readopted its policy of not making up past retroactive exemptions after revisiting the issue. And that is itself a rule within a rule. It's a statement of generally applicable policy that governs.
What aspect of the 2020 rule has a legal effect on you today as we sit here that imposes a right or an obligation?
So every time EPA sets RFS standards, it is operating according to the policy that we're challenging, which precludes it from accounting for past retroactive exemptions. And by doing that,
But the policy didn't come from the 2020 rule. The policy that impacts you today is a policy that was adopted in whatever rule is operative today, which is not the 2020 rule.
I don't think that's correct. The policy stands independent of the standards that were adopted in 2020. So EPA took a policy position. That's a statement of generally applicable policy that will govern in the future. And then in that same rulemaking, it applied that to set percentage standards for that year, 2020.
Policy isn't a final agency action.
It is because it's a rule. Under the APA, I mean, this is standard administrative law. A statement of generally applicable policy is a rule, and that is an agency action, and it governs. And we litigated this in the 2019 rulemaking context in the Growth Energy case, and the court considered what it called the direct challenge to the policy of not making adjustments for retroactive exemptions. And the court said at that point, it was time barred because EPA had not reopened the issue. But in the 2020 rulemaking, EPA reopened the issue, revisited it in response to an administrative petition that we filed for reconsideration of the policy, and EPA determined to maintain its policy with respect to past retroactive exemptions, but it changed its position.
Language in that rule, in the 2020 rule, where they made a full-blown adoption of policy as opposed to a declination to do what a petition for reconsideration asks?
I'm sorry, I don't think I quite followed
What
the
is
question.
the best language? Like normally when they adopt a policy, they say things like, and you want this to be this forward-going policy.
Mhm.
Although it started in 2019 and you didn't call, I mean, if it started in 2019 and you were time barred on challenging it, then I don't know why you get to do it now. So, but your view is that they made some comprehensive announced policy that would govern not just 2020, but all years going forward. And so I'm just hoping you can point me to the language where they did that.
Yes, so I would start at JA 36. And at JA 36, this is in the 2020 rule. The history is that in the context of the 2019 rulemaking, this is the growth energy case, we challenged this policy. The court rejected it on the grounds that EPA had not reopened the policy in that rule during that rulemaking and had actually established it back in 2012. But in the 2020 rulemaking, EPA revisited the whole policy. They did it in response to our petition for reconsideration of the policy. So at JA 36, EPA describes our petition.
Okay, which column are you in on J?
The middle column.
Okay.
And footnote 154 cites our petition for reconsideration. And in that petition for reconsideration, we argued that EPA had.
But where's the text, language in the text? Is it the carryover paragraph at the top, the full middle paragraph, the carryover? What language do you want me to point me to for them adopting a cross-cutting policy that's still continuing to govern today?
Yeah. So first of all, look at footnote 154 at the bottom of the column.
All I see is citations there to a reconsideration petition. So
That's our reconsideration
I understand
petition.
that. Where's the announcement of the policy?
Okay, so then if you go up, the language is, so in the middle, the first full paragraph, right in the middle of the page, says, we are finalizing these changes and in turn, also completing the process of revisiting this issue that we undertook as described above in response to the above noted administrative petition.
Sorry,
That-
very confused.
It's right in the middle of the middle paragraph.
The paragraph that begins in the October 28th proposal.
Yes.
Okay.
And that is talking about our petition, which asked EPA to revisit this policy of not accounting for retroactive exemptions. And EPA says it's completing the process of revisiting the issue. To complete that process, it has to account for what we asked for in that petition.
It's the above noted administrative petition.
Yes, that's the one that's cited in 154.
But how do I, was that the only administrative petition before them in 2020?
I mean, it's referring to the,
Because usually they call the petition for reconsideration is different than maybe an initial petition for action.
well, that is what it's referring to. And that was our petition for reconsideration of this policy. Then EPA.
Okay, but anyhow.
So
everything you're
EPA
talking
then
about here is
says-
not your issue.
It is our issue. The issue we presented in that petition for reconsideration was whether to account for retroactive exemptions, both past and projected. And
Okay, but
in
then they
this,
are definitely addressing your projected ones.
Yes, but they
talk lots about that. They give reasons for it.
yes, but they can't complete the process of revisiting the issue raised in our petition without addressing the issue of past retroactive exemptions, because that's what our petition was about.
What
And
do
then
we
they
do-
say,
What do we do with the, I'm sorry, please finish.
and then they say, I would point you to, well, if you bear with me for 1 second, I have more quotations on this.
It seems like they're talking there about the thing that you wanted about the changing the denominator, getting the expected exemptions factored in. That's 99.9% of what's going on here.
Well, that's what they decided to do, and they're rejecting the rest of what we wanted. And so they are reaffirming their policy of not making the additional adjustments for the past retroactive exemptions. I would also point you to JA 117 in the response to comments. Sorry, that's the 2022 rulemaking.
Yeah, that's the problem that I've got, because in the 2022 rule, they say, we are reaffirming the modification of the percentage standards formulas for the 2020 final rule to account for the projection thing.
Yeah.
And then they say, we have chosen not, they actually say it in words here, as
Yes.
opposed to just silence in
Yes.
2020. They actually say it in words, and they have 3.5 pages of analysis in 2022. We have chosen not to reallocate exempt volume from SREs for past years. That's your second position, the one you're challenging now. But it's
Yes.
number 2.
Correct.
In 2020, whether through revisions to the percentage standard formulas or otherwise. This action constitutes our final and complete response to that petition.
Yes. So you omitted the first sentence of that, which is we are reaffirming our response to that petition.
I'm
So
not,
there-
yes, I understand.
That is,
You can add that, that's fine.
But that
This
is-
action constitutes our final and complete response to that petition.
yes, because
This is where they answered your arguments for 3.5 pages. If anything is an adoption of a policy, I mean, just declining to do something is not a policy that's cross-cutting, forward-looking policy. To the extent they did anything, they just decided in 2020, we're not going to do the sorry, there's some retroactivity already, the big retroactivity that you want.
so
In 2022, because there's just no analysis.
can I ask you to look at,
If I'm just finish my point and then you can do this. And then in 2022, we get 3.5 pages of analysis, textual, programmatic. I mean, all the things that we expect to see when they are making a concrete determination that will carry forward until otherwise changed. And they announce that that is the final and complete response to the petition you're referencing. And so I'm really having trouble understanding how the 2020 decision was a policy for anything other than the 2020 rulemaking, given what they did in 2022.
okay, I'd like to make a few points.
Mhm.
The first is at JA 80. This is in the response to comments from the 2020 rulemaking. They say, we are not modifying the percentage standards to account for past retroactive exemptions. They're talking about the issue that we're presenting here. It's at JA 80,
Mhm.
response to comments.
Mhm.
The second thing is that,
Okay, they just say we're not doing something. Is it, every time an agency says we're not doing something in this rulemaking, that's a policy that's governing for the next 6, 7?
no, not necessarily, but it's against, in the context of what's going on. There is a policy of not making adjustments for any retroactive exemptions before 2020. That's the pre-existing policy. No accounting for any retroactive exemptions. It is a rule that governs all rulemakings. It's not that EPA adopts it every time it conducts annual standards. If it did, we would not have lost in the growth energy case. There would have been no reopener issue because EPA would have just automatically had to redo the policy every time. But what the court recognized was that this is a freestanding policy that governs year over year. It applies generally in perpetuity. We lost that case because EPA had not reopened. In 2020, in response to our petition to reconsider that policy, EPA revisited the issues presented in the policy. That's what it's explaining in the middle column at JA 36. And it says, although in the 2020 rulemaking, the passage you quoted where the EPA says this represents our complete and final,
That's a 2022.
2022 disposition of the petition, it said the same thing earlier. It's only because it revisited the issue all over again. But in the 2020 rule, it said we are completing the process of revisiting this issue that we undertook in response to the administrative
But
petition.
this issue is doing a lot of work there. Didn't say these issues, plural. Your petition had multiple things it wanted. Most importantly, account for projected exemptions. That was, I think, your big thing. You really were, that was, maybe the other was different, but anyhow, that was.
I don't know which was bigger. They were,
Okay, but
they were both
anyhow, for
central.
them, they said this issue, and this issue, all they're talking about on that page is the forward projection. They didn't say these issues. this issue. And this issue is what everything they talk about on that page, which is forward projections.
Well,
So I get that they didn't do the second thing you asked for. I get that. And so that's an implicit denial.
they didn't do it, but they didn't do it in the context of revisiting. This completes their process of revisiting the petition. The petition was about this issue. They can't complete a process of revisiting the issue presented by the petition without revisiting the part that we're challenging here and rejecting it. And that rejection comes more explicitly at JA 80.
There's no doubt that you could argue, could challenge that denial. There's no doubt that you could at the time. But then we have in 2022, what I think is arguably, wouldn't have to decide it definitively, but a serious reopening and reconsideration of this issue, where I think for the first time, tell me if I'm wrong, they devote multiple pages in their response to comments to the very precise issue you're raising here about the prior year adjustments.
They do discuss it more extensively in the
And then
2022 rule, but
more extensively, yes, by hundreds of percentages, more extensively. And they say, this is our final resolution of that reconsideration petition.
they said
Now,
the
that would be
same.
a good argument, and that would be a great argument that 2022 sounds like a conclusive judgment based on a record with explanations of agency balancing policies and considerations, looking at the statutory text. That would be a good argument for, we are locked and loaded for the going forward until we completely revisit this and explain the change in position. But in 2020, because there's nothing other than implicit denial that we're not going to do that. Here's how we're adjusting it. This is one of the things they wanted. This is the issue we're dealing with. So implicit denial of that. That seems like a very good argument that they denied it in 2020, but that was for the 2020 rule.
It certainly was not for the 2020
What's your
rule.
definition of a policy? What's the legal test for knowing when something is a policy that's going to govern over many, many rules, unless and until the agency formally changes its position from a decision not to act on a particular reconsideration petition?
If this were
One issue in a reconsideration.
So first of all, the 2020 rule is the denial of our reconsideration petition as well. So, there's no other document that says we deny your petition or we have acted on your petition. It is the 2020 rule.
Well, there's another document. That's exactly what they say.
But the 2020 rule says we are completing the process of revisiting the issue in the administrative petition. This is the end of the process. The EPA decided to do it again in 2022. That was their prerogative.
That was my point about the issue or this issue.
I just think that it's not artfully worded. They're talking about our whole reconsideration petition. And they're resolving the reconsideration petition. And it is a policy. It is a policy because this is the position that governs all standards. In the growth energy case, we would not have lost on the reopener doctrine and the time bar if it were just a one-off year-by-year decision. Otherwise, we would have been timely because we filed within that 60 days of the 2019 rule. But the court said, no, this was a policy adopted in 2012 at the latest. And it continues. It operates every year that EPA sets standards. And so you had to challenge it in 60 days.
It was adopted and locked in 2012 or 2019. And if you're untimely in 2019, how can you possibly be timely in 2020? Unless you're saying every individual rule is another adoption of the policy.
No, because they explicitly say they're revisiting the issue in the context of the 2020 rule in response to a petition for reconsideration. So they have reopened it. They've reopened the policy for reconsideration.
What factors do we normally look at to find that something's been reopened?
You look at the entire rulemaking context. I think there's a case from 2013. There's a case called Center for Biological Diversity that explains how you do this. You look at NPRM, response to comments, everything the agency says, final rule. And here we have a discussion of there was a policy in place. We are revisiting the policy in response to your petition. Your petition asks for two things. We're giving you the projection, but not the makeup of past, or not dealing with past retroactive exemptions. We elaborate on it at JA 80, where we say that explicitly that we're not adjusting the percentage standards to account the formula. It's talking about the formula for computing percentage standards. And this is all embodied in the regulation at 40 CFR 80.1405C. That regulation specifies the formula for computing percentage standards. In 2020, not in 2022, in 2020, EPA modified that formula to include an adjustment for projected exemptions. And it did not modify the formula for, but it couldn't, if you're not going to account for it, the only way to modify it would be to insert a variable times 0, which would not have made any mathematical sense. So by preserving that part of the formula, that reflects their decision to maintain this as the policy after revisiting it in response to the petition. So they reopened it and they reaffirmed the policy. And then they did it again in 2022. But it doesn't matter they did it in 2022 because the Union for Concerned Scientists case and the American Maritime case established that if you have a challenge to a first rule and a later rule reaffirms the position, even if your challenge applies equally to both, the later rule doesn't moot the challenge to the first rule, and that's the posture we're in.
The interveners cite Alaska v. I guess it's Alaska v. EPA. No, Alaska v. U.S. Department of Agriculture for the proposition that once a rule has been superseded, a challenge to it has become moot because you challenged the new rule that superseded it, and Alaska relies on lots of cases, including a case called Akiachak. But I didn't see any response to Alaska or that entire line of cases in your reply brief.
We respond to it. I don't think we cited the Alaska case, but our response in that brief and my response here today is that the 2022 rule did not, the case law says that when an agency withdraws or rescinds or modifies the earlier rule, the challenge to that becomes moot. That didn't happen here. The position that was adopted in the 2020 rule is exactly the same as the position adopted in the 2022 rule and is the same as the position that EPA has today. It has not changed. It has never been withdrawn. The 2022 rule never purported to withdraw or supersede the 2020 rule. All it purported to do was use a different power, the reset power, to modify a different aspect of the 2020 rule, namely the percentage standards that had been set for 2020. That's the only thing it changed. Otherwise, it left it completely intact, and it used the word reaffirm over and over again. And the Union of Concerned Scientists case and the American Maritime case are more specific about this situation than the Alaska case. The fact that you have a later rule that reaffirms an earlier rule and you have a challenge that applies equally to both does not moot the original challenge, unlike where the later rule withdraws or modifies the earlier rule. That does moot it, but that's not the context that we're in.
Counsel, can I maybe a simplified version of this to make sure I'm understanding? You would, if your argument was in 2020, it was an arbitrary and capricious argument that they didn't sufficiently explain themselves. And then they gave a new explanation in 2022 for the same result, but it's an entirely different, more expanded explanation. You would agree your arbitrary and capricious claim would be moot, right? It would make no sense.
That would make sense to me.
Okay. But your claim in this case is the statute requires them to account for past exemptions. In 2020, they said no. So I think we all agree you could file a petition right then saying not accounting for past exemptions is contrary to the statute. And in your view, all that happened in 2022 is, sure, they gave more explanation, but they still said, we're not doing what you want. And you're still saying that's contrary to the statute.
That's correct.
And that's what motor and equipment says. You can amend, you can do whatever else, but if the regulation that you initially challenged is still the same,
That is exactly correct.
Okay.
And otherwise it would turn into a kind of whack-a-mole game. EPA issues these rules every year. Every year while one challenge is pending, they could say, oh, we're going to reaffirm that policy in this later one and kill our lawsuit. And then we have to go chase them in the next lawsuit. And then they can do it again in the next rule. I mean, during the
What is a little bit confusing here is the relief. So what do you actually envision happening? Is it that the next time we're not going to go back and recalculate the 2020 obligation?
Correct.
Is it that you want them to amend the formula and the regulation, and you think, I guess the next year is going to be 2027, that when they do that, they have to account for every past exemption in setting the new standards?
That is basically right. The way I would frame it is I would say that you could partially vacate the 2020 rule, vacate it to the extent that it readopts the policy of not accounting for past retroactive exemptions. Send it back to EPA. EPA has to reformulate its policy, probably involves amending the standard equation in the regulation, and then that would govern future rulemakings. No one is saying EPA, no one wants EPA or is asking EPA to go back and change the 2020 standards or the 2022 standards or any past standards. This is about changing how EPA operates in the future. So it would have to apply this new policy, this amended policy, starting with 2026, which is going on now. Or if it didn't complete this remand process in time, it might be the 2028 year that it begins to implement this correction. But it would be going forward.
Your brief doesn't ask for vacatur. Your opening brief and reply brief just ask for remand.
Well, that might have just been.
Reply brief said the same thing. I
Yeah,
didn't see
just-
vacatur.
It didn't say vacatur?
In any of your briefs.
Okay, well, I mean, I think you could
A
do.
footnote going, yeah, maybe, maybe not. Footnote in the middle of the brief, but in both cases, you did not ask for vacatur. So you want us to remand the 2020 rule.
I think you could remand without vacatur, given the fact that, we don't need to knock out a lot of parts of the rule. We're not asking you to invalidate it entirely. So you could remand without vacatur, or you could just vacate in
Asking us
part.
to gut the formula that they adopted. It's a huge part of the 2020 rule. You got the denominator wrong because you didn't account for the prior years as well as prospective. That's not ordinarily a remand.
I mean, not ordinarily a remand without vacatur.
Yeah, yes, you want what they did, their formula
Yes.
thrown out as legally wrong, as contrary to statute.
Yes, that's right.
When have we ever done that and just remanded?
I mean, I don't know the answer to that, but I think we were trying to give the court flexibility in how it dealt with this because it is an odd, it is
You can give us flexibility by saying, you could do this. We ask that you first vacate.
yes.
Now, in the alternative, remand without vacatur, but you didn't do that. You only ask for them to go back and think about it a little bit more.
Okay, well, I think our intention was if vacatur makes more sense to do the vacate. And if I can ask for it right now, then that's what I'll do. I mean, I think that partial vacatur, we're not saying you have to vacate the entire rule. And I think that's maybe where some of the unclarity came from in the briefing, because we're not trying to suggest.
Computational formula.
Potentially. I mean, EPA
Yes.
might solve the problem in a different way from changing the formula.
Because was that your argument to them in 2020? Or was it that, no, your formula needs to account for both projected and backwards? Did you give them an alternative?
I mean, in our reconsideration petition, I think we gave them alternatives. And in our comment, I think we also gave them alternatives.
What were the alternatives?
Well, EPA could fix it it could basically add the amount to the numerator.
That's changing the formula.
I mean, they are certainly this is embodied in the formula, but again, EPA could just say,
Change the formula.
From now on, we're going to-
Ways.
maybe this is semantics, but EPA could have a policy that says, we're going to account for this in the future by when we compute the numerator, we're just going to add this amount to that numerator. We're not going to change the regulation, but this is how we're going to implement
2020
it.
formula was wrong.
Effectively, yes. Yes.
Effectively or yes?
Yes, because it embodies the policy that we're challenging.
So in answering the question of whether the statutory text compels this prior year accounting for which you're advocating and have advocated. If we decide that as part of the 2020 challenge you have here, we can't go beyond the 2020 record, right? That's how we look at the statute. Did they say anything of relevance? And as we've discussed already, not that I see.
I think that's correct, but I also don't think it matters because our argument is about the interpretation of the statute and the application of this court's precedent, and that's all you need.
Well, I think so. The 2020 rule has some very considered agency analysis, both of the text and how it operates and programmatic implications of this. And Loper-Bright's quite clear that Skidmore deference remains and that we can consider if it would be helpful and persuasive in a particularly complicated statute like this that involves a very intricate formula. We can consider the agency's expert views, its consideration, and its perspective. We ultimately decide what the statute means, but we can consider it. And so why would it make any sense to decide that question on the 2020 rule record, as you just said, that lacks all that considered explanation and analysis? If we would come to a different answer, if we ask that same question in 2022 or whatever year from the 2022 rule, will we have that? And if that's we could accord Skidmore deference to the agency's views. There's two different statutory interpretation questions before us, 2020 and 2022. If we answer for 2020 and exclude everything they said in 2022, I think that only answers the question for 2020.
Well,
if it would be a different answer, let's just assume, and I know you would argue that it's not.
I don't think it can be because this
But
is.
let's assume that in reviewing the statutory language as to whether they're compelled in their formula, their fractional formula, to include prior years, if it would make a difference to the statutory interpretation question. I'm not saying it would, but if it would, don't we have to decide that based on the 2020 record, 2022 record, where we have that input from the agency?
So I think the answer is no. And even in the old Chevron deference world, the answer was no, because this is a pure question of legal interpretation and application of precedent. And we cited the Sierra Club case in our brief.
Well, pure interpretation and application of precedent are not, I'm not sure what you're saying here, because our precedent on this issue predated Loper-Bright, other than we just had the Sinclair decisions, one of which was post.
It did predate Loper-Bright, but it did not, the relevant parts of that precedent didn't rest on Chevron deference. It rested on the court's interpretation of the statute. So it's still valid.
Clear. My question is, and I'm not saying this is how it would come out, if we would have a different answer on the 2022 record because of Skidmore, Loper-Bright / Skidmore, than we would in 2020, what are we supposed to do?
Well, I think that because this is really a legal question,
if we would have a different answer to that legal question,
yeah.
If we reviewed it on the 2022 record with agency input subject to Skidmore consideration, than we would in 2020 in the absence of that explanation.
Then you should consider the arguments that EPA presented in 2022, which I think it repeated.
To decide this based on the 2020 record.
It repeated those arguments in its briefing here, and we have no objection to those arguments being in the briefing. We're not saying
you told me that we have to consider it on the 2020 record.
Yeah,
if we're going to consider, if we're going to consider on the 2022 record, it seems very odd. Then because we would, if it makes a difference, we would say it was plain statutory construction permitted by law in 2022, but not 2020.
But these are legal arguments, and all the arguments that EPA makes are in its brief in this case. And you can consider
the
all the legal
agency-
arguments. You're
no.
not bound by legal arguments made
No.
outside the record. You
The
can consider
Skidmore
all
deference-
legal
The
arguments,
Skidmore deference is to the agency's expertise, not their attorneys.
which they've expressed time and again in prior rulemakings, which are all before the court, which they've expressed in their brief, which are before the court. Everything EPA wants to say on the subject, it has said to the court outside of the 2022 rulemaking. In any event, because it's a purely legal question, I don't see why you couldn't look at strictly speaking, you look at the 2020 rulemaking, correct. But because it's legal, I don't see why you can't look at any arguments EPA is making about this. We're not making
All rulemakings going forward and backwards for their input on this.
I don't see a problem with that because this is a legal question that we're presenting. And so the court needs to come up with the best answer, and it can look at whatever it wants to look at for the best answer. Even if in this rulemaking, if EPA hadn't articulated something and it puts it in its brief, that's still for the court to consider because it has to get the best reading of the statute. Not the best reading with one eye closed and ignoring a bunch of other stuff, but the best reading. And there's plenty of evidence to use for Skidmore weight, although, again, I think this court's precedent and the logic of what EPA has already said determine the outcome of the merits of this case without any kind of deference toward EPA's position.
Alex, you have other questions?
Okay, so one question about, the merits.
Yeah, I'd be happy to talk about the merits.
So you rely on the word ensure. The immediate question is ensure what? And it seems to me that one basic way of thinking about the question is it year by year or is it cumulative? In other words, and then when you look at the table, which is what it's just to ensure the requirements of the table are met. It seems to me that your position would make sense if just starting at the top, it said by 2007, 8.7 billion. But instead it says 4 in 2006, 4.7 in 2007. Just seems quite clearly to envision a year by year target, not every year you have to look back and make up for prior undercompliance. So just wanted to hear your brief articulation of where that requirement comes from.
I'll try to be brief, but I want to make a threshold point about this, which is that there's really two scenarios in which past retroactive exemptions create a problem. And I think what you're talking about is kind of true up scenario where, there's shortfalls in the past.
And the
And
second
we're
is the
gonna add them
banking,
up.
but which is
Yeah, so I think that as a second scenario. The first scenario to me is the exemptions inflate the RIN bank, and that inflation persists and will persist into the future rule or a year that's being set. There wasn't a past shortfall yet. There's just these extra RINs because of the exemptions. And so in that scenario, you're not trying to true up across past shortfalls. What you're doing is you're saying the standards we're setting for the future will not actually require the amount that we're specifying because those RINs are going to be available and they will suppress the binding force of the requirements. This is actually the logic that justified the projection makeup that this court approved in the reset case. It's also the logic that's in EPA's recent supplemental NPRM for the Set 2 rulemaking. So that's one scenario, and it doesn't even generate the problem that you're pointing to. The other scenario which does generate this problem is if those exemptions created an actual shortfall in a past year because either the fuel was never used or it was used and then that inflation of the bank was already drawn down to avoid compliance in an intervening year, then you'd have a shortfall in the past. And so where do we get this idea that you get to kind of sum up those shortfalls and add them to the future? Well, I understand your point about the text, but this court in the reset case most recently said that the insured duty includes increasing future year standards to ensure that volumes that should have been used in the past will eventually be used. It said that in the context of discussing the makeup of the 2016 waiver, which was added on to the 22 and 23 requirements. But there is this idea that there's sort of an obligation over the arc of the program to bring it into line with that gradually increasing set of requirements. And
I think what we said is that EPA has authority to do that.
You did say that.
It has to do that.
So the question that was presented was about authority because it was challenging what EPA did. But of course, what the court has said over and over, including in the Reset case, in the Wynnewood case, in the American Fuel case, and others, is that this is the insured duty is EPA's core mandate. It is a requirement. And what Reset does is it distinguishes between that mandate and and some discretion in the implementation. So the Reset case says the statute doesn't confine EPA to a particular method of accounting for exemptions. In other words, you have to make it up somehow, but how you do it, you've got some discretion. Maybe you spread it over years. Maybe you put it in the numerator. Maybe you put it in the denominator. Maybe you use projection. Maybe you only do retrospective makeup. The projection is just one part of this and it's optional. EPA could have done it in other ways. So I think the authorization part is a combination of the question that was being framed or the way the case was being framed and the fact that it was really a challenge to the particular method that EPA was using to account for these exemptions. And broadly, there's a lot of time shifting in the program, carryover RINs, carry forward deficits. They're all poke holes in the idea that these are hermetically sealed years and reinforce that this is really a program that stretches over the entire span of the program. And that's what EPA needs to ensure.
Following up on Judge Garcia's question, in that same provision, I guess, O2A Romanet 1, the phrase about promulgating regulations to ensure, in both the first sentence of that paragraph, it talks about no later than 1 year after August 8, 2005. It says you are to ensure that gasoline sold, that EPA, the administrator, is to ensure that gasoline sold or introduced into commerce in the United States. I'm going to skip language there, on an annual average basis. What work is average doing there?
I don't know if EPA has ever spoken precisely to that issue. I think it can be understood to mean exactly what we're saying, that maybe it's not a mathematical average, but actually that across the years, if you're supposed to have 20 in 1 year and 25 in the next, and you do 22 in one and 23 in the next, and you combine them, then you are hitting the requirements on an average annual basis. They're all sort of netting out to equal the total amount that's supposed to be used.
Because it uses the same phrase on an annual average basis in the second sentence, which is for regulations, after December of 2007.
Correct.
But they don't have the annual average basis language later on about subsequent. But correct me if I'm wrong.
No, I think that's the only, in the other provisions that have the ensure language, I think those are the only two that use the phrase on an annual average basis. I don't think that language is, I think it supports our position for the reasons I just said, but I don't think it's essential to our position. Again, the courts recognize this sort of broad sweep of the program insured duty on multiple occasions. The National Petrochemical case where EPA took the 2009 requirements and added it to the 2010. And the court said, yes, the insured duty means that you have to eventually make sure that the volumes are met across the years. Just because you were late doesn't mean you abandon that year. The Reset case said it again.
Right, we said you have to do it across the years. In which case?
In the Reset case, the Sinclair Reset case, the language, I think it's at 891 or 893. And it said, I'll read you the quote. $893. The court deemed unpersuasive, that's a quotation, that the statute does not provide a true-up mechanism on the back end.
Sorry, I'm sorry, which column are you in and which paragraph? On 893?
So give me a moment to get the case. Are you looking at a Westlaw version of this?
I think it's a
Are you in
reported
the
version.
paragraph that begins with "to start, we conclude"?
But it's the next one.
The part I just quoted is in that paragraph, and then I'm going to go further down. So in that paragraph, they say, the refinery petitioners argue the statute does not provide a true-up mechanism on the back end if things don't go as planned. That argument is unpersuasive. The next paragraph, we had made clear that EPA must ensure the applicable volumes are met regardless of delay. And then, therefore, EPA may increase later year volumes to make sure that volumes that should have been met in earlier years are eventually sold or introduced into commerce. That is the lesson of National Petrochemical.
May.
Well, that goes to what I was
You
saying.
said I thought you, and maybe I misheard you. I thought you said they were required by the statute to.
Well, that goes to my point earlier with Judge Garcia, that this is the insure duty is a mandate. It is obligatory. The case was framed in terms of authorization because that's all that the petitioner needed to show. And what the court said was the insure duty is mandatory, but that doesn't confine EPA to a particular method for accounting for exemptions. So there is really the question was, could EPA use this projection method to account for exemption? And the court said yes. EPA could also account for exemptions in other ways, but it has to eventually make sure that these obligations are made up. Now, in this context, it's talking specifically about making up the 2016 waiver. I just want to be clear, this passage is not about the exemption part, but I am reading, it's the insurer duty that is controlling in both of these, both parts of the decision. And I'm, putting together the things the court is saying in those two sections of the opinion.
I noticed in response to Judge Wilkins' question about annual average basis that you answered it by saying average annual basis.
I think the first time that, I did say that.
Yeah, average annual basis would have been very helpful language for you because that average annual basis would suggest you're averaging a basis over the years. But this does not say average annual. It says annual average. And if you think about an annual average of something, that sounds like an average within that year.
Yeah, I'm not sure that really makes sense though in the context of the program. What's required is an amount, not an average, right? The standards are there's a volumetric requirement, which is the number of gallons of renewable fuel, and there's 4 of them. And then there are 4 percentage standards that everybody has to meet to generate one volume. And compliance is not determined by.
How much is sold into commerce. And I think would annual average basis just be a way of saying, we're not going to require it be a pro rata January, February, March, April, May. Instead, as long as the average number over the year, that 12-month period satisfies the required amount, percent calculated as a percentile or not, introduced into commerce. If that's what they mean. It's hard to know. This is
it's
difficult, but it does seem striking that they don't say average annual. They say annual average, which sounds to me a very different meaning.
It may just be more of a drafting error than anything else, because what you just proposed
For a plain text argument.
Our argument doesn't rest on that language.
They got it twice in here.
Our argument doesn't rest on that
Our
phrase.
analysis of all the relevant language suggests that there would have been a very easy way to say your point, average annual, and they didn't. I don't think it's a drafting error. It's here twice.
Well, I don't think it can mean what you just proposed because the compliance is not determined by averaging the months. It doesn't matter what anyone does in 1 month or another month. What matters is what they do over the course of the year.
That's exactly what annual average means.
Well, you would just say the total.
So
Like, why would you go to the total and then back into an
If I
average from
could
that?
ask
That doesn't.
Congress every time why they said it the way they said it, I would be a nonstop job just doing that.
Well, I just think that it doesn't, to me, it doesn't make any practical sense to use that language to mean what you're proposing. The much
Okay.
simpler solution is just the amount that's used in the year.
But
which
your
is what we
response to
do.
him that it supported your view
Yes.
doesn't work because it doesn't say what you need it to say.
Well, I think that what I'm saying is a more sensible construction of that language because the alternatives don't make any sense to me. But I also think that the argument works regardless of that language. I don't think that language has driven any of the court's decisions on the insured duty. The court has still articulated this duty to make up over years. The court has still articulated this duty in the reset case, speaking about the projections that it helps ensure that the future standards will actually require the volumes that are being specified and required and will not create undercompliance. That all comes from the insured duty. That's what we're resting on, and none of that turned on the language of annual average basis.
Any questions?
Just one last question about the breadth of the argument. So it seems like the logic is once EPA knows there was an exemption in past year that results in a shortfall, it has to make up for it. It seems like everyone tries to disclaim that they would have to do the same thing if shortfalls happen for other reasons, like overall fuel production just ends up being lower than expected.
Mhm.
The logic of your argument, I think, would suggest that they do have to make up for that kind of shortfall too. And is that right? And if not, why not? How do you limit your position to just these exemptions?
So a couple of things. In the Sinclair case, in the reset case, the court drew that distinction and said, we're going to require a makeup. But we're only talking about this true up scenario where the exemptions already
that's
created a shortfall, not the prospective shortfall that
Okay.
doesn't generate this problem. But where there's already been a shortfall and you're going to have a true up, the court said in the context of the 2016 waiver analysis, it distinguished between making up for the waiver and making up for a technical error inherent in the projection of what independent third parties are going to do in terms of how much gasoline or diesel they're going to use. And the court said you don't have to make up for those errors, but you do have to make up for the 2016 waiver. We would say that the exemption is like the waiver because these are programmatic actions by EPA. They're not independent actions by third parties. There's two other ways of thinking about this. The second is that the gasoline shortfall doesn't really create a shortfall. It creates a shortfall with respect to the volumetric requirement, but that volumetric requirement under the program gets operationalized as a percentage. And the gasoline shortfall does not create a shortfall relative to the percentage. The percentage still operates, whereas the exemptions create a shortfall not only with respect to the volumetric requirement, but also with respect to the percentage requirement. The percentage ends up being lower than was specified because of the exemptions. I thought I lost my third point. There was a third point.
The problem I have with that is that the reason that the percentage is off is that something was included in the denominator that shouldn't have been included in the denominator, right? Which is the amount of fuel used or introduced into commerce by the small refineries that ended up being exempted, but their production was counted towards the amount in the denominator, correct?
That is correct, but it's one way of understanding what went wrong.
Well, Sinclair Reset said that if there's an error in the projection of the denominator, that's, kind of, how things go. And, these projections can be off. The legal error that has to be corrected is an error in the numerator. That's what Sinclair Reset said. So if we look at it as an adjustment to the denominator, doesn't Sinclair Reset I mean, maybe it doesn't doom your arbitrary and capricious argument, but wouldn't it doom your statutory construction argument?
So first of all, I don't think I agree with your reading of the reset case, because the accounting for exemptions that EPA, for projected exemptions that EPA adopted and was approved in that case was an adjustment to the denominator. And the gasoline is also in the denominator. So the court said the insurer duty allows EPA to adjust the denominator for exemptions, and it does not require EPA to adjust the denominator for gasoline. So I don't think this is about
I'm looking
denominator.
at the Sinclair case 101 F4th at 895.
Okay.
And the paragraph that begins, the two situations are materially different.
Yes. I think what the court is talking about there is specifically about the 2016 waiver, which was a numerator problem, because it caused EPA to specify a lower total renewable fuel volume than it should have. That's the numerator.
And it says that when there's a numerator has been set too low, that is a legal mistake. And the resulting percentage standard is subject to vacature. But then they say that if the denominator is set too high, i.e. incorrectly forecasting total fuel usage, they say that that is a technical error inherent in the nature of projecting events that have yet to occur.
Yes.
So that's not, according to this case, a legal error in the sense of you have, at least the way I read that setting the denominator too high is not a legal error in the sense of violating the statutory mandate.
Mm-hmm. So a couple of things. One is, I don't think that should be read to mean to draw a categorical line between numerators and denominators, because the projection of exemptions is done in the denominator. And the court said EPA can make that adjustment to the denominator. That's one thing. The second thing is that we can implement, EPA could implement what we're asking for through a numerator adjustment.
But
it could increase the volume.
But just my point is, the fact that they can adjust the denominator doesn't answer the question of whether they must. In this case, says, the way I read it, that it's not a requirement, it's not a mandate, it's not something that they must do.
Well, they certainly are not required to adjust the denominator. That goes to the particular methods. The court says the statute does not confine EPA to particular methods for accounting for the exemptions. Maybe it does it in the denominator, maybe it does it in the numerator. But its core mandate, and that is a mandate, is to ensure that the volumes are met. And that includes increasing future years to make up for volumes that should have been used in past years. And that includes increasing future years where there are available RINs that result from exemptions that would cause those future requirements to not actually require the specified amount of renewable fuel. That could be done through a correction through the numerator. That's where EPA has planned the joints. And it can be done spread over multiple years. EPA has planned the joints. But there is this fundamental mandate, which all of this sits on top of. And EPA right now is simply ignoring part of that mandate.
All right, I think we're talking
That's the core of
past
our
each other.
I apologize, Your Honor. I was trying to answer. Thank you.
We appreciate that. We'll give you a few minutes on rebuttal.
Thank you.
May it please the court. I'm Kimmery Kimball here today on behalf of EPA. The portion of the 2020 rule petitioner's challenge here has been superseded. The sole component of the 2020 rule that petitioners attempt to tether their claim to is EPA's change to two factors in the denominator of the percentage standard formula. but EPA fully reconsidered those two factors as well as the percentage standard formula as a whole in the 2022 rule. Accordingly, the 2022 rule has superseded the 2020 rule, and this case should be denied as moot. This case should be dismissed as moot or under the doctrines of waiver, forfeiture, or laches. If
What's your
petition,
best case for theory that, let's assume that I know the 2020, this policy was adopted to not go back to prior years and adjust for those. And in 2022, you look again and say, yep, we were right in 2020, not going backwards. What is your best case that what occurred in 2022 supersedes the policy adopted in 2020 so that it can no longer be challenged?
so two things. First, to your Honor's point before, I don't think it's fair to say that EPA really adopted a policy in the 2020 rule of not going back to correct past year's exemptions. As your Honor noted, there's nothing in the 2020 rule that discusses that whatsoever. But the best case in the fact that the formula has been superseded, I think, is the Alaska v. Department of Agriculture case that Judge Wilkins noted before.
What do you mean the formula has been superseded? The formula is the same.
But the EPA completely reopened the formula to comment on it. It fully considered it. It fully considered petitioners' arguments that past year's exemption should be considered for the
So I guess
first time.
here's my hang up, right? If all we had was the 2020 rule, not the 2022 rule,
Mhm.
you still would have had a final rule that rejects their legal argument. You might have done it without any explanation, but you rejected it and they could challenge it. And we would have before us today a pending challenge to the 2020 rule as contrary to law because it didn't account for past exemptions. And we would adjudicate that today, right? If there wasn't a 2022 rule, that would be live.
Yes.
And then for everything I just said, the 2022 rule doesn't seem to change anything about the legal question. We would still ask, is it contrary to the statute to not account for past exemptions? And that seems like the motor and equipment case. They superseded the rule in all sorts of ways, but they kept the regulation, one of the regulations that the petitioners initially challenged in place, and we said it wasn't moot.
So I think a couple of things. First, the 2022 rule fully considered additional things that were not considered in the first rule. And had this court considered the 2020 rule and found that EPA insufficiently explained what it did,
1,000% agree that any arbitrary and capricious claim would be moot. But a contrary to law claim, setting aside Judge Millett's very good point about Skidmore, has nothing to do with what you said in the record. It's a question about the statute and whether your regulation complies with it. And that, it doesn't matter what else you said in the second rulemaking.
That's a fair point, although I would also note that the 2020 rule was not considering whether or not to address the past year's exemptions. The 2020 rule was specifically considering only whether to address the projections.
But like you agreed with me that after the 2020 rule, when they file their petition for review, there is a live challenge to the legal question. Is it contrary to law not to account for past exemptions? So there was a live dispute, and then you need an argument that something about the 2022 rule moots that live dispute. And I also think you just agreed that nothing about the 2022 rule alters the legal question that was live. Is it contrary to the statute to not account for past exemptions?
That's fair. What changed was the record on which EPA considered the rule. So EPA reconsidered the formula and considered various aspects of the formula. But the thing that changed was the record on which EPA considered it with respect to.
Well, I won't belabor it, but doesn't that mean that if there were an arbitrary and capricious challenge to the extent of the reasoning, that is moot, but the contrary to law challenge is not moot because nothing has changed?
Well, I think that, to Judge Millett's point, the fact that there is this record could provide Skidmore deference. But I take your point that the formula did not change between the two rules. But It is also true that the 2022 rule adopted the formula anew. So if this court were to vacate the 2020 rule, there is no practical effect because the formula is still there because of the 2022 rule. All this court could do is issue an advisory opinion that EPA should also reconsider the 2022 rule.
We can't hold that the regulation violates the statute in a way that requires you to amend your regulation going forward.
You could hold the EPA's adoption of the regulation in 2020 violated the statute, and the EPA should, I guess, consider that in deciding whether or not to reconsider the 2022 rule.
Seems to me that if that is true, then all of our cases saying if there's an ongoing policy that's repeated in new regulations but not meaningfully changed, that they don't really mean anything, because we must be able to grant relief. The relief, even without the 2022 rule, in this kind of a case would be totally prospective. It would be next time you do 2020 rule is set aside. We obviously can't go back to 2020 and make you do it right. But now going forward, you must comply with our interpretation of the statute. And it just seems like that could be a remedy in this case too. When you come up for 2027, you have to follow the statute.
Well, but in order to do that, well, I guess it's true that the legal question is a question that remains in every year. But EPA's full consideration of that question, I think, is something that this court should take into consideration in deciding whether or not to decide the issue. And I take that is less of an Article 3 mootness issue and more of just an equitable doctrines issue, and more of a consideration of EPA had a better record in which it fully considered these issues in a later rulemaking. And therefore, this court should consider this question, or should have considered this question in the later rulemaking. And petitioners had the opportunity to present this issue in the 2022 litigation. But instead of actually arguing this issue, they intervened on our behalf and defended the rule. And
I will yield to my colleagues, but one just small question. What does annual average basis mean?
So I agree that I don't think EPA has spoken to this issue. I do think that it's fair. So two things. First, the actual statutory basis that petitioners use is not 02A1, it's 031. And 031 doesn't speak to an annual average basis. It instead speaks to the forthcoming calendar year, which is very clearly an individual year. I think that 02A1, and this is my interpretation, but 02A1 and 031 can be read together. And the average annual basis is actually referring to the fact that EPA has to do the percentage standard formula in 03.
The annual renewable fuel percentage standard is signified in an equation that's at 40 CFR 80.1505 C, right?
That sounds correct. I don't know the number off the top of my head, but it sounds correct.
And so in the 2020 rulemaking, they said, okay, this is what we think that the annual renewable fuel percentage standard should be. And they set out that formula. And it's got all the symbols and all of that. And the symbols mean different things. And so the rulemaking, I guess what I'm getting at is that what the petitioners, they say that they want to set aside this policy that was articulated and announced in the 2020 rulemaking, but really the manifestation of the policy is the formula, and the formula is in a regulation. And they haven't asked us to set aside the regulation, but isn't that really what they're asking us to do? Or isn't that really the the upshot, if we grant them the relief that they're asking for, is that we would set aside 40 CFR 80.1405C?
I think the relief that they're requesting has been very vague and has really shifted throughout the course of this litigation. So I don't want to speak for what relief they're actually seeking. But it does seem like the only place that they've actually tethered any of their arguments to the 2020 rule is through the percentage standard formula.
Maybe rather than ask you what relief they are seeking, because that is a question better put to them, let me ask it this way. If they come back on rebuttal and say, you're right, that is what we're seeking, what's your response to that?
My response is the same, that the 2022 rule superseded the 2020 rule and readopted that same formula. Therefore, that is the rule that would need to be challenged in order to challenge that formula. Vacating the 2020 rule with respect to the percentage standard formula does nothing to effectuate a change in the regulation.
Would that be true every time? So presumably when you did the 2025 standards, you also stood by the formula in the regulation. Does that mean that a challenge to the 2022 rule would be moot now?
Well, I mean,
Every time you set the standards, you continue to use this policy, and if using it again moots a prior challenge.
So two things. First, the key issue here is that EPA fully reopened this question to comment on it and fully reconsidered it. Therefore, EPA in 2022 specifically was considering this formula and readopted it. But it is also true that by the very nature of the Clean Air Act's jurisdictional and venue provisions, that it is the case that any 2022 rule would be moot by 2025 because Clean Air Act very carefully channels all litigation into a single challenge to a rule, which is the problem here because petitioners are essentially arguing that they get to challenge the same thing twice, and they don't get to do that. EPA superseded the regulation or superseded the rule with the 2022 rule, and that was their only opportunity to challenge this formula.
I feel like we may be confusing terms because it's one thing is to challenge a rulemaking, and it's another thing to challenge an agency policy.
Mm-hmm.
It can cross-cut and be applied again and again in different rulemakings. And so assume there was a policy adopted sub silentio in 2020, not to count for prior years. And then do you consider what happened in 2022 to be sort of the formal adoption of a final position on this prior year's incorporation redress issue that would continue until changed by the agency?
Yes, I think to the extent that EPA has adopted any policy on the prior year's issue, it could only be in the 2022 rule.
And so let's say they challenged it in 2022, and then litigation takes what time it takes, and as a new 25-26 rulemaking comes out, as in 2020, doesn't say boo about this issue, could they not still challenge in 25-26 the policy adopted in 2022 about prior year redress?
Not if it was not reopened. So if EPA reopened the issue in the 2025 rulemaking.
Why would they have to reopen it? That policy would still go, assuming the formula reflected no change. That you just said, that would be the adoption of a policy, a formal agency position on that question. That's really what you guys called it in 2022. And so as long as that's still the live policy, that's going to get repeated in every rulemaking. You don't revisit every policy in every rulemaking.
No, you don't.
You
But
don't
under
revisit the we're going to account for estimates of exemptions we expect will be granted. You don't revisit that or reopen that in every rule, but it continues to be a practice.
It does, but
Isn't that the same thing for what happened, we decided in 2022, unless and until the agency decides to revisit that question, if it ever does? That is the answer.
that is the answer. So petitioner had to challenge it in 2022. To the extent the question is, could they
But you're
challenge
saying
it?
that- And then when that litigation drug on too long, they'd have to challenge it in 2025, 26. And then when that dragged on too long, they'd have to challenge it in 26, 27.
No, sorry, I'm saying the opposite.
Okay,
You
good.
can only challenge it in the rule that actually addressed the issue. The fact that there is a continuing policy doesn't give you a new opportunity to challenge that issue. That's something that is more unique to the Clean Air Act, because the Clean Air Act really channels all litigation into a challenge within 60 days of the rule actually expressing that policy, and it requires people to have submitted a comment on that issue. And for all of the channeling that the Clean Air Act does, it's very specific to, you will challenge this rule once, you will challenge it in the DC Circuit, if it's a nationally applicable rule. And all of that channeling is through 42 USC 7607.
Okay. And then I'm struggling with what to do here. So they say, let's assume policy adopted in 2020 that they want to challenge, because they got no explanation from the agency as to why they were not prior year adjustment. They want to say important question, error of law, both of those approaches.
Mhm.
And then 2022, the agency says, okay, we hear you. We are looking at this again. Here is our comprehensive review and our comprehensive answer. And then you say in terms, and that is our final answer to your petition for reconsideration. Just what you say in 2022.
Right.
And they go, we're all in. We're defending this rule 100%. We have, and make no objections whatsoever.
Mhm.
But they can still go back. It just seems, I don't know, it just seems odd to me that, are you arguing they're stopped, that they're judicata, there's something they made their decision in 2022 to endorse the rule fully, just having no doubt been fully aware of your direct response to their petition for reconsideration and declaration that that's the final answer to it. So they forfeited any challenge
Yes.
to that reconsideration petition?
Yes, they waived or forfeited the challenge by not raising it in the Sinclair litigation. Alternatively, they're barred by latches because they waited until the Sinclair decision was
All those doctrines are a little
upheld.
confusing here because they did, they kept their 2020 petition alive for all these years. So doesn't look like a normal latches case. It's just, I think to an outsider, at least, it would look like you had your objection. Then they answered it and you said, we're all in.
Yes. Well, so I still think that the waiver and forfeiture fully apply. We also argued prudential mootness, that there's no real relief left for the court to offer, and it's an entirely different record, and the first record is stale. All of those doctrines, I think, go towards the how improper this is for judicial review, even if it is judicially available, that the court should instead stay its hand, because petitioners should not be able to do this sort of piecemeal duplicative litigation where they challenge the same thing multiple times in multiple cases. Also, for what it's worth, it's not unusual for this court to put a case into abeyance while the agency reconsiders a rule, and for that reconsideration to affect nothing in terms of ending the first litigation, even if they fully reconsider the issue, would have profound implications, I think, for just how this court operates.
Do you have a view? Your friend on the other side said, if we get to deciding the legal question that they've presented, your question of law, and we consider it on the basis of as adopted in the 2020 rule, that's what they've asked us to do. we can still consider everything you said in the 2022 reopening, I guess you called it a reopening, right?
Right.
Reopening. If we were to invoke Skidmore, we could still consider that, even though that postdates by 2 years the 2020 rule that would be under review. Is that right?
Do I agree that you can consider EPA's analysis in the 2022 rule?
In deciding the legal, not the arbitrary capricious, the legal challenge. If we're only deciding that, I mean, if we decided in this appeal, we're deciding to base just on the 2020, what was adopted by the agency in the 2020 rule.
I mean, I do think that it would be improper because another court has already considered the formula under the 2022 rule and on the record of the 2022 rule. So I think doing this sort of backwards, sort of clawing back the 2022 rule via the 2020 rule, despite the fact that it superseded the 2020 rule, I think is odd and sort of really procedurally difficult. That said, if the court is still going to consider the legal issue, then I think, I think that the agency's statements about its reasoning are very valid to the court's consideration.
Any more questions? Do you have any more questions? All right. Okay, thank you very much. We'll hear from the intervener now.
Thank you, Your Honors. Good morning, and may it please the court. Elizabeth Dawson on behalf of the interveners, obligated parties, American fuel and petrochemical manufacturers, and the small refineries. First, I'd like to start with just addressing the mootness question, and in particular, how important it is to remember that the 2022 rule, what we're calling the 2022 rule, not only superseded 2020, but also fully replaced it, because that rule covered the compliance years 2020, 2021, and 2022. So it is not just that EPA reopened and reaffirmed its legal reasoning with regard to the formula. That 2020 rule is completely replaced. As such, there is no effective relief that this court could grant that would redress any injury that occurred because of the 2020 rule.
When you say replaced, are you saying that there is a specific part of the 2020 rule that in the 2022 rule said that part is no longer effective?
Correct, Your Honor. With by the time EPA promulgated the new 2020, the replacement 2020 rule, it changed the percentage standards to effectively reset them to the amount that had been produced in 2020. Because if you will recall, this was kind of a sui generis situation where we had COVID. And so EPA was reconsidering the 2020 rule in that context. So again, focusing on this part about relief and the fact that the petitioners are effectively seeking advisory opinion, I would go back to that Alaska versus USDA case, because in that case, the court noted that it would be entirely inappropriate for the court to do as the state would want and issue an advisory opinion to guide the agricultural department's rulemaking. And that's exactly what they're seeking here. They are seeking to have EPA consider this court's opinion on the policy articulated in 2020 in these upcoming rulemakings. And as we know, EPA is now already in the midst of proposing the second version of the set rule for 2026 and 2027. So they are hoping to influence that future rulemaking instead of dealing with whatever EPA ends up with on a full and complete record in that rulemaking, in which they will have a full and fair chance to argue what they would like with regard to the meaning of the statute. But that is not appropriate for this court to consider at this time because there is no effective relief that can be had for 2020. And unless the court has any questions more about mootness, I would just turn to the merits for a moment. if I can have 1 minute. I just think should the court reach the merits, it should deny the petitions because there is no statutory authority. There is no reason to reconsider whether small refineries should have to reapply for exemptions that they were already granted in a previous year, and because it wasn't arbitrary or capricious for EPA to decide not to reallocate in the 2020 rule.
Why is it saying that small refineries are essentially losing an exemption that they got in the prior year? If we were looking at this as just like a true up where the denominator, we got the EPA got the denominator wrong in the prior year.
So petitioners are asking EPA to increase future year standards based on what they deem to be under compliance or missed volumes in previous years. That would be taking those volumes, which were lawfully exempted amounts that small refineries under the statute shall not have to comply with, and porting them over into a new year. And that would effectively, even though it would be spread out, would require small refineries to justify once again why they shouldn't have had to comply with that percentage of their obligation for the prior year. And I think this also goes to the point that the court was making about whether this is really the only true-up mechanism that petitioners are seeking with regard to small refinery exemptions versus other reasons that the volumes may not have been made. And there, for example, in Sinclair, where this court was deciding on EPA's decision to add a supplemental volume because of a legal error in 2016, that is very different from lawfully granted exemptions that EPA is by statute required to provide to small refineries that demonstrate that they qualify. That is not really a missed volume. That is a legal entitlement to a small refinery when it demonstrates that it is deserving of the exemption. So it is not the case that it would be that EPA is not ensuring that these volumes are met by not accounting for a lawful exemption granted in a prior year.
Any other questions? All right.
Thank you, Your Honor.
Okay, Mr. Lane, we will give you 2 minutes to rebuttal.
Thank you, Your Honor. A few brief points. When we filed this case, we had a valid challenge to the policy. The other side doesn't actually dispute that. They concede it. Their argument is that it became moot. But all that happened in the 2020 rule was an elaboration of the explanation for the position. And that alone cannot render our original claim moot. They don't cite any case that says that.
They replaced the 2020 rule.
Like, it's clearly not true. The 2020 rule itself says that all it's doing is modifying the 2020 percentage standards. That's it. Otherwise, it explicitly says it's reaffirming everything that
The percentage standards
are the application result of
by the formula, the formula.
Yes, they're determined by applying the formula.
And you challenge the computational formula.
That's correct. But we're not our challenge here is not about the application of the formula to particular numbers or percentages. It is the formula that stands independent of how it is applied in a specific year. So that's the same policy that we challenged in the growth energy case. And the court said you have a direct challenge to the formula or the policy, and you have a challenge to the particular percentage standards that were set. Court separated the two. I said the challenge of the policy was time barred because EPA didn't reopen it. Here, EPA reopened, they revisited the issue. That's uncontested. The other side never argued reopener in their briefs. So we have a live challenge to the policy. And all they're saying is it's moot because there was an elaboration of the explanation. But Skidmore can't render cases moot just because the agency goes out and says more about the reason in a later action.
Mootness is one thing. What about waiver and forfeiture? Why didn't you raise this argument in the Sinclair reset case?
Well, the Union of Concerned Scientists, American Maritime, and Motor and Equipment give us the assurance that we were under no obligation to raise it in the later case. In those cases, the court said, we're not going to require a party to have to go out and litigate in a second case.
This is the later case.
No, this is the earlier case.
No, but
this is the 2020
in practical,
case.
literal sense.
Only because we agreed
This
to
is
an
the later
abeyance.
case.
I mean,
Right.
while this case was pending, the 2022 rule came out. We never agreed that our challenge here became moot because of the issuance of the 2022 case. We stood on the sidelines because we thought that the 2022 case could foreclose our claim here. if the refinery's challenge to the projection had succeeded, then we believe that would also mean we would never win our claim. In addition, at that time, EPA had announced a new exemption policy that would have wiped out all exemptions from 2018 onward. And we looked at that and thought, if this holds up, we really don't have to worry about these exemptions anymore. So there's no reason to force, the cost and, the time for us, for the court, litigate this issue. So we'll wait and see what happens. And then the exemption policy was
2022
reversed.
Rule said it was looking at your reconsideration petition and gave pages of answer and said, this, the 2022 rule, is our final answer to your reconsideration petition. And we see you coming in saying the 2022 rule, we are all in. You didn't stay on the sidelines. You were there, as I recall, intervening in support.
That's not
Of the rule.
correct. We intervened in support of the rule
Okay.
with
The
respect to,
2022 rule.
yes, with respect to the
I understand.
projection.
So that makes it.
We
worse. You
weren't
were
saying the
there.
whole thing was good.
You were, they gave you an answer. I mean, it's the strangest thing I've ever seen is we say, we are really upset in 2020 about this decision on our reconsideration petition. And in 2022, they say, okay, we will think about it again. And here is our answer. Lots of explanation. And this 2022 rule is our answer to your reconsideration petition on this precise issue of what to do about prior years. And then you show up in the litigation and you don't say boo about it. You don't say we support, as parties do all the time. We support this part, but we don't support this part. It was right in this regard, but also this should have happened. You came in and you didn't say boo. It sounded, anyone looking at your brief there would have said, well, I guess they're satisfied with the answer they got to their reconsideration petition in the 2022 rule. And then lo and behold, we're like, oh no, we're still unhappy with our answer from 2020.
Well, the only issue that was presented was the projection issue, and we weren't a petitioner. We were intervener. So we were intervening
You could have filed
to
a petition
defend. We could
challenging
have,
it.
but we
You
didn't.
chose not to. You made a strategic decision.
Well, we had a
not
right
to.
not to because of cases like Union of Concerned Scientists. We had a valid live case.
Concerned scientists involve them between the interim rule and the final rule, objecting to something in the interim rule and then coming in the final rule and saying, we are on board and not saying a word about their objections that they still had. Did that happen in those cases?
The case was decided before the second litigation occurred.
So
So there was no occasion for it. This happened because we agreed to
I
in
know, so
advance.
This is very
But
different.
It is different, but it's not different in the fundamental
You made a
way.
decision about how to respond to the 2022 rule, which incontrovertibly was EPA's answer to your reconsideration petition. And now you're asking this court to review the 2020 answer to your reconsideration petition. You spent all that time pointing to that footnote where you said they're answering our reconsideration petition.
Yes.
So you want us only to look to their 2020 answer to your reconsideration petition, but not your 2022 reconsideration petition when you had every opportunity to challenge it then and you didn't.
It's the same policy. All they did in 2022 is reaffirm the policy
So it
that we
looks like
had
you got a
already
lot of, you got
challenged.
zero explanation in 2020. I understand what your challenge would have been. And you got lots of explanation and you didn't say boo about it.
Yeah, we didn't need to. We
Well,
had
then
this
you
case,
made the decision
we
not to.
preserved, I mean, this case was preserved. It was on ice. We had a valid challenge. It was in abeyance.
It's astonishing to me that it would have been very easy to file a second petition. Because, they've now answered again our petition and there's still no improvement.
Well, this was
You're putting an awful lot of
I mean,
hope
this,
in having this answered based on the 2020 record.
this was the first time that EPA revisited the policy and decided it. I mean, in some sense, this made more sense. This was the one that all the second one did was reaffirm.
They told
This
us
was,
they didn't decide. They were dealing with one particular issue. And then you must have pointed out to them that, hey, we still haven't got an answer on this. And so in 2022, They gave it to you. 2020, they were
No.
rulemaking in the middle of COVID.
Respectfully, Your Honor, I disagree with that characterization. Our petition for reconsideration that was before the agency covered the past retroactive exemptions. And in the final rule, EPA said, this is our completion of the process in responding to that petition. And we are sticking by not accounting for past retroactive exemptions.
You
And then 2020, they said, we meant it. We said final last time, we're saying final again.
Hold on. You were saying that in 2020, EPA decided, gave you your answer to your reconsideration petition.
Yes.
What other evidence other than what's stated in this rule do you have for that? For instance, does an EPA have a docket? And don't they put an entry on the docket when they have closed or resolved a reconsideration petition?
The petition is listed on a webpage. I don't believe there's anything about a decision on that listed on that page. That is, I don't think there's anything stated. I could be wrong, but I don't think there's anything stated there about a decision. But everyone, I mean, we understood and the agency understood that the 2020 rule was the decision on the petition. I do have one other piece of evidence.
Then why did they spill 3 pages of ink on it in 2022?
Well, they went back to it. I mean, we're an important stakeholder in this process. The refineries are, the agency listens to what we say. There are conversations in between. They go back to the issue. I'd like to read, this is more evidence. This is from the 2022 rulemaking, 2022, JA 117. We are reaffirming our response to that petition. That's saying, we decided the petition in 2020. We resolved the issues. It was the completion of our process. And now we're revisiting it once again. And we're standing by what we did in response to that petition in 2020.
And this, at the next sentence, this action constitutes our final and complete response to that petition. I'm assuming you guys saw that when the 2022 rule came out.
Yes, but
This is our final and complete response to your petition, and yet you chose not to seek review, not to petition for review, chose to go in and support and not have any qualification. If there's something in your brief from 2022 that drops a footnote saying, by the way, we're still unhappy about that, let me know. But you, as far as I can tell, you didn't say anything. You got this answer. We're looking, you're a stakeholder. We've had conversations. So we are looking at your petition again. And we are giving you all the answer that we have given in here. And yes, we're reaffirming, we've looked at it all and we've come to the same conclusion. Agencies sometimes do that, sometimes they change.
Yes.
But they looked at it again and told you this is a final and complete response to that petition.
Yes.
And you didn't do anything about it.
Because we had this
You
case.
wanted to, because you were happy with the 2020 response, even though you just told us you had conversations, intervening conversations, you're a stakeholder, they care about your views.
We weren't happy with the response. We were litigating. We had filed a petition to review the response. We disagreed with it and we had that case preserved. We filed it timely. It was in abeyance and we knew we could go back, or we believed, consistent with the case law, that we could go back to that case.
So is it your position that the formula at in the CFR 40 CFR section 80.1405C, that formula is wrong?
Yes, that formula embodies a policy that we say is invalid as a matter of law because it excludes any accounting for past retroactive exemptions.
So why didn't you just ask us to set aside that regulation?
I don't think there's a difference in asking you to set aside the rule or act on the rule that makes that regulation and to set aside the regulation
Well,
itself.
Was that particular formula first adopted in the 2020 rule, or had that formula been adopted?
So there was a formula that predated the 2020 rule. That prior version did not include any accounting for retroactive exemptions. The 2020 rule modified the formula to insert a variable for projected retroactive exemptions, but not a variable for past retroactive exemptions. And that is the formula as it exists today.
So the formula at this particular subsection, 80.1405C, was modified in 2020
Yes. And not modified in 2022.
and not modified in 2022.
Correct.
It's history.
If we had brought this challenge in
Can I just
2022,
follow up on that real quick?
Yeah.
It's history at the end of the rule shows that it was modified in 2022.
not in the relevant respect. Maybe there was some other change, but not with
It doesn't show
respect to,
anything in 2019.
that's correct.
I'm sorry, I thought I heard you say they had changed it in 2019.
No, the 2020 rule modified
I
it.
misheard you then, okay.
The 2020 rule modified it. The 2022 rule did not modify it. At least with respect to the exemptions,
There
we're
was
talking about.
modification in 2020 and then 2022.
Yeah, but the 2020 rule did not modify it with respect to exemption accounting. There may have been some other, the formula does a lot of things. There may have been some other change that I don't recall, but it wasn't about exemptions. The
So
only modification for exemptions was in 2020.
When did this formulas first not include a prior year account for prior years?
For exemptions, probably, I mean, I might go back to 2010, 2011, 2012, somewhere around there.
That's the first time it didn't do what you think it should have.
That's why we lost the growth energy case in the 2019 rulemaking case, because
So you were untimely.
we were untimely.
Okay.
I also, just to speak to the vacator point, I wanted to just mention our footnote 2 in the reply. We do ask for vacator there. I probably would formulate the language differently in retrospect, but we were asking for vacator with respect to
Where? What page?
footnote 2. It's on page, well, the relevant sentence is on page 6. The footnote starts on page 5.
Contrary to intervener's objection, the court could invalidate the challenge policy and remand the rule without vacature,
Yes.
or it could vacate the rule. So you're like, well, you could do either one. So I look to what you're actually asking us to do, and it's remand.
Okay, well, vacate and remand, partially vacate and remand, please.
Have you asked for a declaratory judgment? Can you get that under the EPA?
I mean, the Clean Air Act allows you to declare the action unlawful. I believe it's formulated similar
But
to
you
the
haven't asked
APA.
as a form of relief.
Honestly, I don't think I've ever seen a brief in an APA case that, or at least in these Clean Air Act cases, that does it as a distinct form of relief that's requested. If you did that, we would be happy with that outcome as well.
Yeah, I'm just asking the question. I don't.
Yeah.
I'm not quite sure how they all intersect.
Well, I'm quite a bit over. I had a couple more points, but I will
Questions?
recede if I
All right.
exhausted my.
Thank you, Reg. We have exhausted you, I'm afraid. So
Thank you very much, Your Honor.
We're grateful for your help, your assistance and assistance from the government and intervener. The case is submitted.
Thank you.
Second, the honorable court established precedent of West District of Circuit of Trinidad